All right. Say again?
There's a microphone here if you need it.
Oh, no, I'm good.
It's up to you.
Yeah, it's a small room.
Okay.
So, I'm used to, yeah, I could do this. In court, the microphone's always broken. I got to get to the judge, so this is not a problem. Yes, good morning. Thank you, everybody. It's very rare for a person to be introduced as the local professional bastard and actually take that as a compliment. But I do take that as a compliment. That's actually one of the nicest things people say about me. You should hear everything else they say about me. But like I said, I do take that as a compliment. No one ever calls their friends and be like, hey, do you have a nice lawyer? Do you have like just a really polite, great, soft-spoken attorney? No one says that. It's like asking for a blind doctor. No one really wants that guy either. So I do take it as a compliment. And yes, one of the main things we do in our practice is we have a very large eviction practice. And as Fran was saying, evictions, especially in LA County, anywhere you are in LA County, it's a war. The way I describe it is 50 years ago, if you wanted to be an owner of a single-family home or two, maybe an apartment building, just as your side hustle, and have a regular job at the same time, you could do that. That was a thing you could do and make a little bit of money and build a little equity, and that could just be your retirement thing. Back then, it was like playing amateur high school softball. That's about the level it was. Right now, owning rental property in Los Angeles is like the NFL during playoffs. If you don't have your pads and 100 people on your team and $500 million to pay for your roster, you are going to get killed. Period, killed. Someone will run you over. It is professional football now. It is not something you could do as a side hustle. If you are attempting to do it as a side hustle, you will find out very quickly it is not a fun game to play. And it requires a great deal of time and energy, and that's why my firm is here, is to try and lower the amount of time and energy you have to spend on it so you can get the best advice given the circumstances that we're in. A lot of the time, the circumstances that we're in, not really within our control. We are operating in an environment where the government and the local political forces are actively telling you, both online, in their political speeches, and in the laws they pass, that we as a society do not like you, landlords. We don't like real estate people, period. We wish you'd all just die and go away. That's what they are telling us, and that is the war that we are fighting, because what they don't understand is that if all the real estate people go away, homelessness is going to be a much bigger issue than 50,000 people. Everybody's going to be homeless, or everyone's going to be living in public projects, and we all know how pleasant and well-run those are. So that is the fight that we are fighting. The way I like to start all these talks is to give you a little bit of an update on what's going on in terms of landlord-tenant news. The latest thing that happened, of course, last week, the city of LA they didn't pass the law yet, they just passed the resolution to ask the city attorney to write the law, but then they're just going to rubber stamp it, which is to redo how they calculate the RSO rent increases. So that means for all the properties that are subject to rent control within the city of Los Angeles, not the county, and we'll talk about what the difference is later, but the city of Los Angeles, it used to be there was a floor of 3%, a cap of 8%, and then you would get 1% extra if you paid for all the tenants' gas, or 1% for the electric. You'd get 1% for each. And then if a tenant moved in a new person, basically without asking you, you could increase the rent by 10%. So what they changed it to was a floor of 1%, a cap of 4%, and it's actually tied to 60% of the CPI, got rid of the 1% for the gas, rid of the 1% for the electric, and got rid of the 10% for the extra people. Yeah, it's murder. Chances are the rent increase next time they actually do the calculation is going to be set somewhere around 1.8%. Just a little bit over half of the CPI. So they're literally stealing the money from you, because CPI means the amount of inflation. That means the amount your money is worth less. And they're saying we're going to take that rent and only allow you to increase that by half of how much it's worth less. So literally decreasing the rent if they're doing it for less than CPI. Because CPI just means you're keeping it the same, right, effectively.
So you might want to call all the 4-unit owners and ask them if they've thought about trying to convert their properties to tenant in commons and selling them individually.
Yeah.
Because I don't see a way. I think that as a landlord, I wouldn't do it anymore. I wouldn't buy and be a landlord in this town.
Right.
There's no reason for it.
Right. Now, this does pertain only to the RSO properties, so that means the building was built before October 1st of 1978, or could be a newer building if it was, if the old building was RSO, demolished, and then you put a new building on top of it. If you didn't qualify for an exemption from the RSO, your new building is RSO. All right? And I actually, unfortunately, have a building like that. I didn't really have much of a choice, because the way to get the exemption is you have to give 20% of the number of new units to affordable. Right? A lot of the times it works if you're doing a very large building and you need to use that, you have to have that many affordables in order to get a density bonus. And that's how a lot of people get 35% density bonus. If you take 11% of your units and give them to extremely low income, you get a 35% density bonus. Usually it's just a couple more to get to the 20%, and then you can be exempt from RSO for the rest of your building and have the density bonus. You're very much, as a developer, incentivized to have a few affordables in your building. That's the kind of strategy, that's the kind of statutes that we kind of want to see, because it works hand in hand with the need for affordables plus the need for just general more housing, both affordable and market. But if you can't do that, if you have a smaller building, then your new building is probably going to be RSO if it was built on top of a demolished old RSO property. Now, if your building's not RSO, then you're in a little bit of a better space. Your rent control, if it's subject to the California rent control, which means your building is more than 15 years old, is going to be set right now at 8%. That's fairly healthy, and most people can live with that. And then
for buildings that are 15 years or newer, you can raise the rent 8%?
No. So for buildings that are older than 15 years, but newer than October 1st, 1978.
Okay.
So it's two different ways of calculating. One is set to a specific date and said either your C of O is before or after. One is a rolling 15 years. That's the state statute. You might know it as the Tenant Protection Act. You guys know the addendum that you give when you do a lease, and it says the just cause eviction or tenant protection addendum, and there's a box that you have to mark if it's a single family home? Yeah? Okay, so that act, that law, it's called the Tenant Protection Act, or also known as AB 1482. That's the thing that implements rent control across the state on all properties except for the ones that are exempt. Basically, the ones that are exempt are any properties that are newer than 15 years old. So if you're older than 15 years old and you're in the city of LA, you'll at least be under the state rent control. If your C of O for your property is now before October 1st, 1978, you may also be under RSO, unless, of course, you're a single-family home or a condo or a townhome or something like this, something separately alienable, and you really only have one unit on the lot. A lot of people say, oh, I have a single-family home. And then 3 months down the road, they'll say, oh, yeah, but we also have an ADU that we rent to a second tenant. You do not have a single-family home. That's called a duplex. I don't care if the front house is a 15,000 square foot mansion and the back house is a 7,500 square foot, which would also be a mansion if it was sitting by itself. If you have two units on the same lot and you rent them to two separate people, that's called a duplex.
You have to pay relocation on the single family once that ADU is created and rented.
Once the ADU is created,
So
correct.
Changed everything, and the agents are not telling the owners that.
Yeah, it's very important. This is very important. So the state passed a bunch of laws that made it very difficult for the local entities to restrict people building ADUs. Why? Because it's a very cheap way to increase the amount of housing stock. So everyone is like, great, I'll go out and get a loan, I'll make my ADU, I'll make my $1,500, $2,000 a month, everything's fantastic. What they didn't tell people, at least in the city of LA and, and other places that have local rent control, is that let's say you have a single-family home in Los Angeles. Most of them built in anywhere from the 1920s to the 1960s, right? Most of the houses you sell, fairly old, unless you're doing one of the newer ones. Okay. Those houses are single-family homes. They're not subject to the RSO at all because all single-family homes, if they're true single-family homes, are exempt. Now, you have this house that's built in the 1960s. You go out and you build your ADU. That's built in, we'll call it 2025. Well, now you don't have a single-family home anymore. Now you have two dwelling units on the same parcel. That's a duplex. Your ADU has a C of O from 2025. It's not going to be subject to rent control. It is going to be subject to the local city eviction control, but not to the rent control. But your single-family home, which used to be exempt, has a C of O from 1960. Guess what? You rent out that single-family home. If you're not living in it, it's rent control.
All because of the ADU.
Because the ADU.
But if you rent it without building an ADU, then you can still rent
Well, there's
it.
no ADU, right? If there's no ADU, it's a single-family home.
Okay.
It's just one parcel. Then you're still not RSO. You're still going to be subject to just cause eviction in the city of LA, but it's just the one parcel. By adding the second parcel, that's how you turn a single-family home into a duplex. Of course, they didn't tell anybody that. So that's something to keep in mind when you're telling someone who might want to buy a property, oh, just add an ADU and get some extra income. Be careful. There's more to it than that. Yeah, extra income, extra headache, exactly. More money, more problems. So that's the update and some additional information. Who has questions?
How do you get somebody out? I have a question. You have a person who's not paying their rent.
Yeah.
Most of the people, when they're not paying their rent, I'm not seeing the old 3-day pay or quit or anything like that.
Sure.
These people, they're in the school of hope and pray. I'll call them again this week. I hope they're going to get it to me. Or they'll take a partial payment.
Okay.
We're seeing so many people not paying.
So here's the deal. Here's the deal. We still do the 3-day pay or quits.
Okay.
We do quite a lot of them. But yeah, it's not easy to get someone out. So for example, right now, it used to be 3 days to pay or quit. That was calendar days. Then they changed it to court days. Then when you file a UD, ever know what UD stands for?
No.
Unlawful detainer. It's the fancy name for an eviction. So anytime you hear someone say, I need to do a UD, that means I need to do an eviction. All right? Now, it used to be that when you served them, they got 5 calendar days to respond. Then they got 5 court days to respond. Now it's 10 court days to respond. So everything in an eviction is taking longer and longer.
So you're talking 30 days from a 3-day pay or quit at this point?
No, I'm talking, and sometimes if you can't catch them, and you have to do what's called a subservice, meaning serve someone other than the person you are trying to evict inside the home, or if you have to do service by what's called post and mail. It's a long story, but you have to serve them the lawsuit in the same way that you would serve them the 3-day notice, but you need to get the court's permission first, and you need to show that you tried 3 or 4 times and you couldn't catch them. It's very easy to evade service. You just don't answer the door. That's it. Not very difficult. So let's say you did that, theoretically speaking, from the time you served the 3-day to the time you actually got to the time that they have to respond could be 5 or 6 weeks. A person can actually sit in their unit in Los Angeles County and do nothing in response to your 3-day notice. Not pay, not leave, not even file an answer to the UD, and they could sometimes sit there for about 4 months.
Our longest eviction, Johnny is sitting here, was 4.5 years. 4.5 years, and how did we get him out? Well, the guys that came in that actually bought the house, they came in weaponized.
Yeah.
Is that a nice way of saying it? They walked the guy out.
Yeah.
Literally walked the guy out. We
So-
couldn't do it for 4.5 years legally.
We've had situations that have gotten less than legal.
What's the success rate?
What's success rate?
Right, I mean, how many people that start the eviction process actually have the tenant leave?
Oh, like 90%, 95%?
I don't want to scare you off, that's why I'm asking this. So in most cases, do people actually leave? What's the average time from the?
6 months.
6 months, okay.
Average time in LA is 6 months. And let me explain why. It's approximately 6 months to resolve the UD. They might not be out by then. Okay? So, it used to be, before COVID, that this is the procedure. you have to you have to serve the 3-day notice, file the complaint, however long it takes to get from complaint to judgment, and whatever kind of judgment it is. Let's just put that to the side for a second. Complaint to judgment. After you have the judgment, you go and you submit a writ of possession to the court. That is a document that comes from the judge to the sheriff that says, I am the judge, I am the officer of the court, and you are the levying officer, sheriff. Please go lock this person out. It's an instruction. Then you take that, you take the judgment, take the writ, you take sheriff's instructions, fill all that out, drop it with the sheriff. The sheriff is the one that actually has to go do the lockout. In other words, pull the person out if they're still there when the sheriff comes. Now, in 2019, that was 2 weeks. They would schedule your lockout within 2 weeks of the time you gave them the paperwork. It is currently 8 to 12 weeks. Wow. Right? And that is because no one wants to be a sheriff. It's very low paying. It's got a very bad stigma among young people. So no one who's like 22, 23 years old wants to go to the bar, and everyone's like, where do you work? Oh, I work at a nonprofit. Where do you work? I work at whatever, Capital, bank, whatever it is. Where do you work? I'm a sheriff. Ugh. No one wants to be that guy. So they can't hire people. And then if you are going to be a sheriff, you want to be knocking down doors and taking down drug dealers, not taking little old ladies out of their house. So it's very difficult for them to find staffing. I really don't blame them. It's hard for them. So anyway, that's why it takes 8 to 12 weeks now just to do the lockout. So if you take the 6 to 8 weeks it takes to get from, let's just say, even if they don't respond, from notice to judgment, and then the 8 to 12 weeks that it takes to do the lockout, a person could just sit there and do nothing, literally nothing, and sit there for 4 months. So it's no joke. That's why some people are hesitant to start, and it's why a lot of the times we end up settling a lot of cases.
So what
now,
does that mean?
What does settling cases mean?
Does that mean the tenant who is not paying rent now, I'm going to have to write them a check to get them to go?
I like to translate all of the problems. Hold on.
What happens?
I like to translate all the problems that we deal with in real estate, whether they're landlord, tenant, real estate, construction, I don't care. No one here is in the real estate feelings. Everyone here is in the real estate business. If you make real estate feelings decisions, I promise you, you will make bad decisions. So you need to translate every single problem into math. Math doesn't lie. Math doesn't like tenants or dislike tenants. Math doesn't like landlords or dislike landlords. Math is not mad about the law or okay with the law. Math is just math. Math is numbers. Math doesn't lie. And math always gives you the right answer. Always. So you translate every problem into math, math spits out the correct answer. So if it costs $15,000 to $20,000 to go gamble at the casino of eviction court, or you could pay $10,000 to buy yourself a judgment by giving this deadbeat who owes you money $10,000. So I can pay $20,000 to gamble for a judgment 6 months down the road?
Maybe a year or more.
Not a year, but it could take some few months. Or I could pay $10,000 to buy the same thing. You'd have to be an idiot to go gamble. So that's why we pay them. They know it, by the way.
But that only makes sense when they're willing to accept the payment.
That's correct. Now, sometimes they're not. Sometimes the amount that they want.
That's why he has job security.
Right. Now, sometimes the amount they want is $100,000. Well, now it's better to go gamble. Right? See? Math gives you the answer. Question over here.
Yes, can I tell you a real problem right now from
Sure.
one of the clients, and you can guide
I can give you some free legal advice, you mean? Sure, no problem, yeah.
Okay, so true story happening now. Tenants, the owners are my clients,
Yeah.
and we leased that place 4 years ago.
What is it? So okay, this is very, very important. Whenever you start asking real estate questions, hold on. The most important thing you can find out, number one, where is the property? Now, when I say where is the property, we'll get back to your question first in a second. Where is the property means what city is it in? Anybody know how many cities are in LA County?
Tons. 88 plus.
88 exactly. Okay, 88.
Who knew Susanna?
So, of those cities, about 15 to 20 have some version of rent control or just cause eviction or one or the other or both. They're all different. And you have to comply with each tiny little piece of each one in order to know how to do the eviction correctly. Now, you may be sitting on this side of the street and be in City of LA, or on this side of the street and be in City of West Hollywood. And there are different rules and different places you have to deal with. We once had a building where that border ran through the middle of the building. And it was West Hollywood for some things and LA for other things. And the address does, yeah, exactly, Beverly Hills and LA, that's another one. But the address does not tell you anything. We once had a building where the owner thought the building was in Glendora. Fantastic, no local eviction control, no local rent control. Guess what? It's not. It's an address of Glendora, but it's in the unincorporated part of Los Angeles, which does have rent control, which means his whole plan was kaput. Because he couldn't do the substantial remodel evictions that he wanted to do. Very, very important to check. The only way to check is you go on lavote.org, look for the precinct maps, you type in the address, and it'll tell you exactly what city it's in.
Okay,
Right?
you're still
So,
at 1 million.
condo, where is it?
Condo 90016, Los Angeles.
That's probably City of LA.
Village Green. Okay.
Probably City of LA.
4 years she has been there, a single woman with 2 kids. We signed the lease, she has paid. A year ago, apparently, there was a leak from upstairs.
Yeah.
Insurance companies paid and everything, but she had so much stuff inside that she wouldn't go out for the owners to repair.
Okay.
She wanted 15,000, they said, you're crazy, it's 5,000 a hotel. Between one thing and the other, a year passed.
Yeah.
The management company didn't do anything, they didn't push. Desperate 2 months ago, they called me, we need to sell, we can't deal with this woman. I'm like, what's the deal? So I learned that everybody paid, but the repairs have not been made. This woman decided that because the repairs have not been made, she's not gonna pay rent anymore.
Okay.
So the management company says, yeah, actually, yeah. So they call me, and I'm like, okay, so who's in charge, or why is she not out, or, you're
Yeah.
dealing with 8,000 between, just pay the 8,000. Get her in a hotel, go in, and get your, she's hijacking this
Okay.
whole thing. I go in, she has 1 dog and 2 cats that are not in the contract. She has not paid rent for 3 months already.
Yeah.
And then I sort of say, okay, we're gonna sell.
Yeah.
Maybe she wants to buy, maybe she wants to buy, it's gonna be I call her agent, she can't qualify.
You don't
She
say.
does not qualify. She says, you know what, no, you need to pay me.
How much?
450,000.
450,000?
So the owners are like, wait, what? Yeah, so I said,
Okay.
what is 28,000, it seems to be the price for her to move out.
Okay.
And she's like, no, because I am disabled.
So,
Oh, okay, so disabled, let's say 20, 30.
Can I
Guys,
also
just
be
give her,
also?
just give her 35,000, get rid of it, like, what
Okay.
are you gonna do? No, she wants 450, and now she's suing,
okay.
because, so they say.
Because of the mold?
So they say, thank goodness, we finally are gonna talk to someone, at least we're gonna talk to a lawyer.
Okay.
Now they're negotiating,
Okay.
thankfully, and now they're at 150. What? I'm like, okay, so they're there. And they are now happy, they say, well, at least we're gonna sue her back. I mean.
Did they tender this to their insurance company?
Huh? So the insurance company already prepaid for the,
No, I mean, did they tender the lawsuit to the insurance company?
I don't know.
See, here's the
So
thing.
that's what I'm.
All right.
Ridiculous.
Lot to unpack here.
The person they hired has to be knowledgeable about directions that they can
Exactly,
take.
and the
this.
management company.
Okay.
Come on.
There's a lot to unpack here. I get this story once a week.
Okay.
Yeah. This is a very common story. We're also, just so you know, we're a full service landlord firm. So we do everything that landlords, property managers, owners, developers could possibly need. We have an entire eviction department, but we also have an entire civil litigation department. We're actually panel counsel for CIG, one of the largest insurance companies in the state, who still writes habitability and landlord insurance. So we have, I don't know, maybe 150 habitability lawsuits that we're defending right now in the office, in addition to a whole bunch of other landlord and real estate work that we do. So we get stories like this all the time where it's a combined landlord-tenant / habitability / mold issues. There's a lot of things to understand here. Number one is a lot of people don't know this, that when you buy landlord insurance, that is not just property or fire insurance. It's not just damage insurance. There's also a Part B to that coverage, which protects you against lawsuits. That's the liability part. You ever see on the declaration page where it says how much you're protected for, and say the condo cost, I don't know, $1.25 million, and they'll always put that as the limit of liability, $1.25 million. How much does it cost to rebuild it, right? But then there's a second part that says $1 million per occurrence, $2 million aggregate. What is that for? That's for liability insurance. That's for third-party claims that are made against the landlord.
Depends on the third-party claim. Be very careful here. Because wrongful termination or wrongful eviction is not a coverage in the state of California. Under a policy, you have to actually have it through your umbrella policy.
Well, I've seen a lot of policies that cover eviction.
No, I understand. Wrongful eviction. Almost every guy, I'm a wholesaler.
I understand.
Home insurance carriers. I can tell you by wording, you will get what's called a reservation of rights.
Sure, but you get a reservation of rights in every tenant.
So if you have an umbrella policy as a consumer, you don't. And then what happens is, I'm just being very careful.
Yeah.
I'm saying there's coverage when there's potentially.
I'm not saying there's coverage. I'm just saying that that's potentially what's there.
Yeah, I just want to make sure clarification on that coverage.
If you
Sure.
own property, you need to have an umbrella policy regardless.
Yeah.
That's just where life is.
Yeah, I'm not saying that there's always coverage for every single claim. What I am saying is that there is a liability component to virtually every property policy. It may cover you. A lot of the times there's habitability exclusions and mold exclusions. You'll always get a reservation of rights letter because every single landlord-tenant claim always comes with at least a breach of contract cause of action, not covered, and a request for punitive damages, also not covered. Because those are never covered, you'll always get an ROR letter. Question in the back.
Yes. I want to ask you if your firm does that for a landlord. This actually happened to me. That was a few years ago. It was no problem, but this is the story. I had a tenant, I'm a landlord, and he died on the property.
Okay.
So
That's an easy way to get them out, by the way.
I contacted my deceased tenant's family member.
Yeah.
They moved the belongings very quickly.
Okay.
So it was resolved very fast. I was very fortunate. Now I have a client, the same situation. The tenant died without will. So the landlord, the owner, don't have the rights to remove the furniture out. It's been 6 months. The county sealed the property.
Right.
So what's the landlord's right? The landlord gets very frustrated.
Sure.
The tenant deceased, but
How did he die?
it's just natural cause. I mean, on the property, it happens.
And you're telling me the county,
Because he didn't have a will, they're saying they can't enter the units.
the-
The landlord doesn't have the right to remove the person.
Oh my
from the
God.
no, that's not the issue. First of all, that's not the issue. The issue is the tape. The issue is the fact that the morgue still has their tape on it so that you can't get into the unit.
Correct.
That's the problem. It's not that you can't take the stuff out. If someone dies and they have no next of kin, the lease is over after 30 days by law. So if you can get into the property, just take all the junk out. It's not a problem. The problem is going past that tape. And so that's where you have to talk to the, it's the coroner, thank you. The county coroner's office, and push them, somebody has to push them to take that tape off. Alternatively, didn't hear it from me, just slice it and go in.
Oh, yeah, come in.
I can't tell you how many times, a lot of the times, it's like, it's easier to ask forgiveness than permission. Not all the time. Please do not take that to the bank. That is not legal advice. That is not legal advice. But there are times, I will give you an example. We could talk about your specific situation later, but I'll give you an example. One of the biggest scams going on right now is identity theft. And so people, what they're doing is you can buy packages online. There are TikTok advertisements for the package. I shit you not. You can go on TikTok, find a person who manufactures an identity for you with credit reports and bank statements and gives you fraudulent cashier's checks. It takes 7 days for the bank to tell the landlord, hi, this is a fraudulent cashier's check. Yeah, there's no Wells Fargo bank. That doesn't exist. So, yeah, you just missed it, you know? So it takes a while. By that time, you've already given them the keys and the person's already in. Now, some of my landlords will call me and say, what do we do? There are a few options here. Number one, do the regular old eviction. That'll take as long as any other kind of eviction, okay? Number two, I've had people who come in with specialists, okay? They'll kick the door down and say, hey, here's $2,000, $3,000. Get the F out if you know what's good for your health. It works. And if you can, and other people, if you can figure out when they're in and out, will just figure out when they're out, and without calling a specialist, change the locks, get all their crap, put it on the street, and say bye-bye. Now, number two and number three are not legal. I'm not telling you they're illegal, and I'm not advising you to do that. But I will tell you, they're very fast, they're very cheap, and I don't send an invoice for them. So, that's information for you to chew on. Question in the back. What's the cost of an eviction? It all depends on the level of resistance that we get from your tenant. Now, here's the problem. In LA County, it is a different world. It's a different universe than if you cross the county lines. In LA County, there are now, by my last count, 16 different nonprofits whose sole job it is to make landlords' lives difficult. They provide free defense to tenants in any UD. Doesn't matter what they're doing. Didn't pay the rent? We'll defend you. Killed your neighbor? We'll defend you. Started a bar in the basement of your building? That's a real story. We'll defend you. Yeah, no joke. Hold on just 1 second. So those people have no incentive not to make it take a very long time. They know what they're doing because this is all they do. And they have a political mindset. These are the DSA communist people that you hear about in the news. They believe that you, as a landlord, are an evil person for profiting off of providing rental housing to other people for money. That should be a human right, like free air and free water and free food and free everything, right? Because, you know, we could just do that if we wanted to and everything would be fine. But no. That's what they think, and so they make it their life's mission to make these evictions take a long time. If your tenant goes to one of those guys, it will take a long time. It will cost a decent amount of money. Chances are it'll cost more than $5,000. How much more? Depends on how much we do. Discovery, trial, depositions, motions. I've had them cost at an extreme, very rare, only happened once or twice, more than $100,000. Very rare. Right. Most of the time, the average is about $5,000. If they don't go to one, you might be in and out for less than $5,000. All depends on what kind of war we're dealing with.
If you beat the nonprofit, you beat the nonprofit.
Do you get your attorney's fees? No, you do not.
You do not.
No, you do not. Most leases, especially the ones you're using, the car forms, right? They have an $1,000 attorney's fees cap in it. That is there for the protection of the landlord. Never change that. Never change that. Because a lot of the times, it'll take once, twice, sometimes 3 times, because the landlord will have done something, not met some kind of technicality. You do not want to give those nonprofits an opportunity to ask for a $20,000, $30,000, $40,000 attorney's fees bill. because the court will give it to them, even if they won on something stupid, even if they won on something they could have figured out early on in the case. They will give them that money. So you always want that attorney's fees cap. Question in the back.
So would you recommend like a wire instead of a cashier's check, one, and then number two, from a broader perspective, entering into the contract, should somebody consult a real estate attorney, put addendums into the car form to help protect themselves?
Against fraud?
No, against a tenant pulling some moves. I guess there's something you can do ahead of time.
There is nothing you can do to get around the laws. I got this during my last talk. They're like, oh my God, I have such a good idea. Why don't we just put in the lease that the tenant waives all of his rights under the RSO?
We've had people try and do that.
Oh my God, that's genius. No one's ever thought of that before. Of course it doesn't work. The law says that you cannot waive your RSO rights. It doesn't matter. They could sign that. They could go on video and say, I want to sign this. You could have 15 witnesses. It could be signed in blood and notarized. It doesn't matter. You cannot waive your RSO rights as a tenant. Nor can you waive any of your state rights that you have as a tenant. Anything that's done for the public is non-waivable in a contract. Doesn't matter how many times you write it. So unfortunately, there's nothing you can do or put it in a lease that will help you get around the RSO laws. A lot of people then ask, what's the point of having a lease? There are things in the lease that you really do need. For example, show of hands, without a lease, just as a general idea. Who thinks that if you're a tenant, you're allowed to just sublease your apartment willy-nilly? You're all wrong. No hands. You're all wrong. You're actually allowed to sublease your apartment. Yes, you are. Yes, you are. By law, if you have just an oral lease, you can sublease your apartment. There's nothing in it. Hold on, everybody.
Fishing rod.
Don't get ahead of me. Yes, in the written leases that we have, it says you are not allowed to sign or sublease. That's what makes it so that you can prevent it from doing them. Prevent them from doing that. It's not because it's written into some statute. Another thing is, when is the rent due? No, by law it's actually due on the 30th. The reason it's due on the 1st is because it says so in your lease. Right? So there's a lot of things that are in leases that are still enforceable, and you never want to not have a lease. So if some landlord tells you, gets frustrated and says, well, if I can't evict people and if I can't get around these laws, what's the point of having a lease? There's very, very many good points about it. So never not have a lease. Okay. Any other questions? Yeah.
When you serve a 3-day notice to repair or quit, is it true you have to go and record a copy of it to the city or so that in case they come back and they lawyer up, that they see that on your end you did your part to not just serve them, but also put a copy with the city?
So that is a true requirement. There are many cities, including the city of Los Angeles, where when you serve a 3-day notice to pay or quit, or actually any notice of any kind, cure, quit, 30-day notice to quit, 60-day notice, doesn't matter. Any notice that tells the tenant, you gotta go. You have to also file a copy of that with the city or county or whatever it is, depends on what city you're in. In the city, you file it with LAHD, and you can upload it, thankfully, and get proof that you did that. Now, if you don't do that, they can go and check and just do a Freedom of Information Act request. They get an answer within a couple days. If they say, no, we never got it, then that's a defense to the UD. Doesn't matter if they really didn't pay the rent. It doesn't matter. If you didn't do all the technical things, one of them being to upload this notice, then that's a defense to the UD. Now, to answer your second part of the question, why do they make you do this? It has nothing to do with showing that you proved your part. It's just to make it more difficult, because a lot of landlords don't know the requirement. And so it's another hurdle which will make the landlord have to start all over again, which will keep the tenant in their unit for longer, which is exactly what they want. And second, they actually use it as a marketing ploy. The city takes that information and says, oh, this is how many eviction notices are getting filed all around here, and then they use that to make landlords look back. Look how many evictions they filed. It has absolutely no practical purpose other than to give the city ammunition for more communist propaganda. No joke.
Are you going to be able to stay for a moment?
I can stay.
Okay, perfect. So,
Oh, are we stopping now?
what?
Are we stopping now?
I'm going to stop you because we're...
Okay.
If no more questions, and if you stay, people can ask questions.
Okay.
And you need to send your contact information to
Yeah.
me, and I will forward it to everybody.
I have cards too, so I'm old school, low tech like that. Still have cards.
Okay, Angelo called me for something, and it was taken care of the same day. Okay, so there is a big difference. You have to have, there's so many people who call themselves eviction attorneys, and they're not. And it's scary out there. So please, if you get in this situation, please make sure that you get the best that we can offer somebody that's full service in eviction. Okay?
All right. Thanks, everybody.